Speaker, thank you for allowing me to participate in the debate on the Land Court Amendment Bill 2014. I shall confine my observation on Clause 7, 8 and 10. I shall start with Clause 7 of the bill, in particular the new proviso, bracket C under Section 175, which reads, the issue of documents of title for the land over which the caveat has been lodged either before or after the date of coming into force of this paragraph, in accordance with Section 244 upon the completion of the subdivision of the land, and the caveat shall continue and remain in force and entered in the registrar for any of the new documents of title in respect of the land as that or interest stated in the caveat. Thus, Speaker, by having this proviso, it is understood that it will give way to the registration of memorandum of surrender and alienation, because currently, as I am told, there are many cases which I can give one example is like the MJC development project at Batu Kawah, which under the current law, the Lands and Survey Department cannot replace the master title with individual title or strata title, because the existing law forbids the registration of the memorandum of surrender and alienation without obtaining consents from all caveators. It is always the case that some of the caveators are either nowhere to be found or their whereabouts is unknown. That is why the Land and Survey Department requires the introduction of this new proviso to be passed as a law to simplify the procedure of subdivision over the land which are used for development project, so that subdivision can be proceeded without the hassle of obtaining the consent from all caveators. However, my worry is this. By having this proviso, how are we going to differentiate the effect of lodgement of caveat following an ADTC with the caveat which is lodged following an objection by certain parties over the entire development project? If I were to read and understand correctly, this proviso will allow the registrar to carry on with the subdivision of title, even though there are caveats lodged over the parcels of land by some unhappy parties. Hence, I would like the Minister to enlighten this august House over this issue. To me, this proviso can cut both ways. Tuan Speaker, on Clause 8, which introduces a new section of 1978 that states, no action or claim for compensation shall be brought against the government arising from any inheritance, acquisition, purchase, transfer, dealing in land over which native customary rights subsist as provided in paragraph 1 of the proviso in section 5 bracket 2. Tuan Speaker, when we deal with or talk about NCR land, we are not just talking about or dealing with individual person over the matter. As you are aware, most NCR lands does not belong only to a particular individual, but to the whole communities of families within the communal. So, in view of this new section 1978, which do away the government responsibilities, or put it more bluntly, the government will never get blamed or be responsible despite wrongdoings is in practice during the time of transaction are taking place by the authorities or the relevant parties involved, or there is any act of omission or default on the part of registrar. How will the rights of the NCR landowners or other inheritors, which are not directly involved per se in the transaction, being protected under the law? The state government always boasts about protecting the rights of the native in Sarawak, whether rich or poor. But by introducing this new section and obviously washing off its social responsibilities, how is the government going to protect those natives who might have been cheated, those who are poor and illiterate? How can a state government be so irresponsible over your own right? Tuan Speaker, it is foreseeable that by having this section 1978, the security of rights of the natives over their lands will be jeopardized. because the government will not even bother whether the deals are properly carried out in accordance with the laws or not. At the end of the day, many natives will be left with no lands, and their NCR lands will be gone, and there will be many grabbing of NCR lands by certain greedy and dishonest parties, which some, I believe, are politically connected to the persons in power. As a responsible government, such Section 197A should not be introduced and passed in this August House. Tuan Speaker, I shall now move on close stand of the Land Court Amendment Bill. At the moment, as far as I understand, under the present State Planning Authority structure, the functions of the State Planning Authority as spelled out in Section 229, bracket 1 of the Land Court can only and or must be carried out by the Minister. The Minister has to be sit in the meeting twice a month to listen to all the cases submitted to SPA, which is believed to be troublesome to the Minister, who has a very busy schedule. In the event the Minister does not sit in the meeting, the cases will keep on going and no decision can be reached. That is why public always complain that it takes ages for SPA to approve a simple application. I can see the logic of introducing this subsection 229 bracket 2 for the purpose of performing its function under subsection 1. The State Planning Authority may, with approval of the Minister, establish a panel or panels consisting of any of its members or any other person to be appointed by the chairman. But Mr. Speaker, there is no mention as to the number of panels in the new section 229 bracket 2, as well as no definition as to who are the other persons. We definitely cannot allow any Tom, Dick or Harry to be seated in the panel. In my view, the number of panel and so-called other persons must be spelled out clearly in the section, as we do not want a bloated panel or a rojak panel that cannot function properly, yet incur unnecessary and extra expenditures. With the establishment of the panel under section 229 bracket 2, in my view, it is also necessary to amend the new section 229 bracket 3, which in this bill has been omitted. If we look closely at the new section 229 bracket 3, the SPA may, by notification published in the Gazette, delegate any of its functions to any minister or the director or any other public servant. This particular new section 229 bracket 3 does not give SPA the delegation power to the panel, which SPA intends to establish after the passing of this bill. There is no mention of the word panel or panels in the new section 229 bracket 3. Therefore, after the passing of this bill, we will have a panel which has no power to carry out the functions of SPA under section 229 bracket 1. So, Tuan Speaker, what will happen to this panel or panels after it is set up? The SPA will have the power to establish or set up the panel, yet there is no delegation of power to the panels, which are supposed to be carried out the functions of SPA. In other words, the panel or panels will end up as a toothless tiger. If this is the case, we can foresee that the panel will only function as a filter with no power to approve the applications which are under the purview of the panel. It will definitely curtail the purpose of the establishment of the panel. Furthermore, the members of the panel are appointed by the minister as the chairman of SPA. So this panel may not be impartial, because the members sitting in the panel will definitely become a yes man to the minister. Favoritism is definitely at play, and every order of the minister has to be obeyed. The panel will likely to function in such a way that only cases which are pleasing to the minister are being pulled up to SPA for approval. Therefore, if such a case is allowed to happen, the integrity of the panel will be at stake. It will be very difficult to ensure that genuine cases submitted to SPA for approval are not being jeopardized. One speaker, the last point I would like to make is, may we know how is the minister or SPA going to monitor this panel? The panel can consist of anybody in view that other persons are not properly defined. The issue of integrity of the panel cannot be taken lightly. Like us in the opposition bench, we are playing the role as check and balance over the ruling party. Anything or any policy implemented which is not to the benefits of the people, we shall speak up without fear or favor. So in our case of the panel being set up by SPA, it is important to know who is supposed to carry out the role of check and balance over the panel, so to ensure that all cases are properly put up for decision at the SPA level. The above are my brief observations on the Land Court Amendment Bill. I urge that the State Attorney General and the Ministry concerned would take serious consideration to the brief observation I have just made. With that, I conclude. Thank you.
Mr. Speaker, thank you very much for the opportunity to allow me to participate in the debate on the Land Court Amendment Bill 2014. Mr. Speaker, for hundreds of years, the natives of Sarawak have had their own system of laws in managing their land as contained in the ADUN of the community. The fact that the natives still have the land intact today shows that the traditional customary laws, the ADUN of the natives, must have been well sufficient to manage the matters of land in the community. Today, the natives have no problem with their lands. The problem is with the people who try to get their lands with no regard and no respect for their ADUN and their right to the ancestral land. So instead of enacting law to allow this and that to be done to the native lands, in fact, laws should be enacted to prevent those who try to get their lands. As government has the fiduciary duty to protect the interests of the natives and their native customary rights on land. We have seen in many parts of the world and in our very own country, in Sabah, where the natives are fast losing their lands and many are already displaced from their ancestral lands. There could one day become landless and homeless people on their own land. We must therefore be very careful when we attempt to make changes to the ADUN through the legislation in this day one. ADUN are best left to the people of the ADUN and is the ADUN institution of the native communities. Otherwise, if we try to legislate it in the day one, it could be very well jeopardize the very existence of the ADUN and thus its people. For if you lose the ADUN, then you lose your soul. Since time immemorial, the Pamakai Manoa has always been known to the natives as the territorial land of the longhouse or the group of longhouses. In the olden days, the whole community will go to war to defend and fight for the Pamakai Manoa because it is their land, their territory. And apart from agricultural purposes, the Pamakai Manoa is also the hunting and fishing grounds where the natives also collect jungle produce and live from it. Within the Pamakai Manoa, there are the Temuda and the Pulau Galau, which are the land reserved for the communal use. So all that, Pamakai Manoa, Temuda, and Pulau Galau forms the native customary rights on land. It is now the accepted worldwide view based on common law that a native is synonymous with the land, the forest, just like the trees are part and parcel of the land. Mr. Speaker, in the amendment of our land code today to allow sales on the NCR land, the government must set up a native land board to register the NCR land and to oversee the land transaction, as well as setting up guidelines and policy in NCR land transaction. For example, like setting limits on land sold bigger than 10 acres must be approved by the authorities, or other policies by the board to promote improvements on the land after full consultation with the native landowners. A tribunal must be set up to hear any disputes that so arise, as the court will require evidence to consider and is more adversarial in nature, whereas a tribunal would be more conciliatory in its approach. And on top of all this, Mr. Speaker, equally important is that awareness program on land transaction must be in place so that the rural community can understand the whole issue more comprehensively, thus using their land wisely for maximum benefits to themselves and to the community. With that, Mr. Speaker, thank you very much.
Member for Kamak. Mr. Speaker, thank you for giving me the opportunities to participate in the debate on Land Court Amendment Bills to 2014, which was presented by the Deputy Chief Ministers, Ministers of Rural Development and Ministers of Modernization and Culture this morning. The presentation and amendment to about 9 sections of the Land Court, Sarawak Land Court